Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m., Reddy Neumann PC does bring in immigration updates. Emily, what do we have today?
So today we have big news on the planned furlough of USCIS workers. Originally that was set for August 30th after being postponed once before. We had an emergency legislation passed the House recently that would have somewhat solved the problem by drastically increasing premium processing fees. We also had bipartisan letters being sent to USCIS and DHS from Congress, and that finally seems to have worked because today they announced they're canceling their plans for furloughs and they're going to maintain their operations through the end of this fiscal year, which technically ends September 30th. So we get about a 1 month delay to see what happens next to solve their budget
Emily,
problem.
every week you're changing your story. First you said there's going to be furlough on August 13th, then you said August 31st, then you were saying one time there is not going to be furlough until October 1st, and now you're telling, 2 weeks ago you said it's furlough from August 31st, and now you're telling there is nothing until October 1st. What's going on?
Well, in my defense, I did say that I didn't expect there to be a furlough because they're going to work it out. But basically, this is just a lot of back and forth, a lot of political movement going on. People are claiming the Trump administration is basically trying to break immigration as a political tactic, and the Democrats are using it on their side as well to show that the Trump administration can't seem to get his act together and make this agency work properly. So that's a lot of what's been happening with all the back and forth and the changes of plans. But there's also been a lot of pressure placed on DHS because the numbers don't lie. They say that they have enough funding to get through the end of the fiscal year, so why do they need to furlough people now? And they finally agreed to at least that statement.
Emily, you said it's only until September 30th because the year ends for the immigration on September 30th. So there is no furlough at this point of time until September 30th.
Well, they didn't even say they're going to furlough September 30th. They just said there's no furlough right now. We have the funds to be able to maintain things through the end of the fiscal year.
Which is September 30th.
September 30th, but they do have to give the employees advance warning of a furlough. I believe it's at least 30 to 45 days. So I don't think they've done that. So it may not be September 30th. They're just saying that that's what they know they have the funding for.
So it may extend all the way to for a long period of time. Mm-hmm. I've also seen the statement from the USCIS saying that now the increase in the filing has been there, so they're collecting more money. Well, the filing was there when the COVID was in a serious situation. People were not coming to work. I think so. They started accepting more applications, is the way that I look into. Emily, now with the COVID situation and Trump using COVID to ban the family immigration for a period of 6 months or more, 6 months. So now those family immigration green cards are going to be given the last year, that means the 2020 wasted family immigration preference categories will be given to the employment-based category. Now, how do you know that if those things will be given to EB1 only, or is it going to be only given to EB2 or EB3? Right. Do you have any criteria for it? How many numbers are at this point of time confirmed that the extra green cards are available for the employment base?
Yeah, this is all set out in the statute. So the statute says that we have these different categories and they are divided up by percentage amounts that each category gets. The statute also says that unused family-based green cards spill over to employment-based in the following year. So they just take a total number, whatever that total number might be. It's at least 140,000, but of course this year it will be more. But they take the total and they divide them up based on the percentages that are set in statute. So it will be the same 28%
for the EB1, 28%
Mhm.
for the EB2, 28% for the EB3. So assuming that if we are going to have 100,000 extra green card, minimum of 100,000 extra green cards, so this year we're going to have EB1 28,000 extra, EB2 28,000 extra, EB3 28,000 extra. Does it mean that the Indians are going to get in the same proportion as what they're getting, or the Indians have better chance of getting? Indians will take a bigger number in this one.
Yeah, Indians will definitely take a bigger number because we do still have the 7% cap, but because the rest of world is unlikely to use up their larger share, those extras from rest of world spill sideways to the most backlogged countries based on priority date, which is generally going to be India and China. So they will benefit.
So there is no backlog in EB1 for the rest of the world. There is no backlog for the EB2 for the rest of the world at this point of time. There's only backlog for EB3, and that doesn't seem to be a significant backlog. So what you mean to say is that the 28,000 green cards for EB1, a good number of them will be taken by Indians, because Chinese, a little bit of the Chinese too. And mostly when it comes to the EB2, and it's more backlogged, Indian nationals are there, the most of the 28,000, or all of the 28,000, should go to Indian nationals then.
Mm-hmm.
I mean, there may be a little bit variance on the number that we have, what we have made a statement on the 28,000, especially how many things will be going to Indians. I have had a stats that I published it in my website, rnlawgroup.com. Based on that, though, if you look into it, the number of green cards Indians that are waiting in 2011 seems to be around 30,000 labor certification approved in 2011. And in 2012 also about 30,000, and about approximately 30,000. In 2013 it seems to be about 35,000. So approximately for those 3 years, there are about 100,000 green cards that people that are waiting though. So if you take into consideration that the priority date was current until May 1st of 2010, going forward from there, I'm expecting the dates to move at least until 2011 and to an extent 2012, because there are a lot of people who move from company to company and they refile the applications again. So my expectation is the priority date for Indian national should move to 2011 and maybe to 2012. What do you say?
Yeah, and we also have to take into account that the number of labor certifications doesn't include family members.
Of course.
So,
and so what do you mean that in 28,000 family members also should be added in there?
Mm-hmm.
Of course, they should be. So maybe only 14,000 number of people will be getting the green cards. So it may be 2011 then,
Mm-hmm.
according to our estimate, maybe not 2012, depending on how many number will be available. So there is good chance that we are expecting the priority dates to move starting from October 1st all the way to September of 2021. Our expectation for Indian nationals is somewhere between 2011 and 2012. That is what we are expecting, the dates to be moved. So please plan accordingly. If you are intending to change to a different company and then you're going to leave the I-140 and you're going to move to a different company though, you may have a problem. The reason is that if you move to a different company, they have to file a labor and I-140 application that will take about a 1 year period of time. And if in that period the priority date becomes current and you don't have the company to file the adjustment of status with the current I-140, you may miss the boat. I have seen people missing the boat in 2007. And those people who missed the boat in 2007, it took them 5 years to get onto the next boat, which was actually in March until about 2012. Mm-hmm. And the people who missed the boat in 2012 are still waiting after 8 years. So you may want to seriously consider, if you have an I-140 approval with a company, is it a right time to move? Maybe not. That is my expectation, so I want you guys to be careful if you want to make any changes. Any other comments on that?
No, I would agree with that, definitely.
Emily, I see the Department of State right now saying that, well, they can waive the personal interviews on the U.S. When they go for the visa stamping, though. Now, that's not what I see in the consulate, though. Secretary Pompeo said that for the next 2 years, he is waiving the requirements for the personal interview for the visa applicants. And this was continuing from, from April onwards. There was a waiver, and he extended it by 2 years, though. But I don't see people getting the waiver and getting the visa stamping in India, any of the countries. Do you see that?
No, it's at this point, those people that have been able to get a visa, it's basically limited to F1 students who are in emergency situations with fall semester starting this week. And then they opened it up for a few limited services for F1s, but for everybody else, there's just, even if you're able to make an appointment, it's far off in the future, and they're being canceled and rescheduled again. So this doesn't seem to be solving itself anytime soon.
And Emily, what is going to happen with the academic students who are supposed to come on an F1 visa?
Right, yeah, if they're not able to get the visa, they basically have to do the remote option if their school provides that, and their school can, roll them over to the following semester to try to come in for the January start date.
Any information on the biometrics, Emily?
Biometrics, we are slowly getting appointment notices for those that had filed earlier and been canceled. They're rescheduling those, but it is extremely slow. I mean, we've got so many people waiting, and they just come in a trickle, like maybe 3 a week is all we're seeing. So it is a very slow process. There's just nothing you can do that actually works that we're finding. They're just saying it might take 60 days, it might take 6 months, we're not open yet, you just have to wait.
Yeah, with regards to the USCIS interviews, that is normally for the people who have filed the adjustment of status in the employment-based category, though, I'm seeing a significant movement in the interview process. I'm seeing a lot of people getting interviewed. Yes, is it to a full scale what it's supposed to be? No, I don't see that thing, but we have seen a significant amount of people getting interviewed for the employment-based. And we're also noticing that there's a pressure on the USCIS because there are 140,000 green cards available for this year. If they don't use it, there might be a big backlash on them by the Congress because, hey, we gave you 140,000 green cards to be given, and people are waiting in line. Why did not you give it to them? So there is a question mark that might pop up for them. So I'm thinking that because of that, they are trying to interview as much as possible. Emily, a lot of times people, when they file the non-immigrant visa, work visas though, there are some people who file for the consular processing, some people who work for the change of status. Can you explain what's the difference between both the things and why sometimes one is better, sometimes other is better?
Yes, I'm getting a lot of questions on that right now on my blog, immigrationgirl.com, especially as we are getting more and more approval notices from this year's H-1B lottery that were filed back in April and May. So if you have requested a change of status, that means you're currently in the United States in one non-immigrant visa category, and you are changing to another non-immigrant visa category. So you're requesting a change of status from one category to the other. When you get that approved, it means that you do not need to travel or obtain a new visa in order to be in that new status. It automatically kicks in. So for these H-1Bs that are being approved in this lottery in the CAP season, they're going to start on October 1st. If it was approved with a change of status, that new H-1 status automatically kicks in on October 1st. There's no need to travel, no need to obtain a new visa stamp, even if your old visa stamp is expired. That's change of status. Consular processing is either you're outside the U.S. at the time of filing, or you intend to travel while it's pending, or for some reason there may be an issue with your current status, or maybe it's expiring before the start date of the new category and you're not eligible to change status. If you have an approval with consular processing, that means you do need to exit the country, apply for a new visa stamp at the consulate, and then come back to the U.S. to actually get into that new status and activate it. So generally, if you're in the US, change of status is an easy option because you don't have to travel and you don't need a visa. But again, there are some people where it may not be a good option, particularly if you have issues with your maintenance of F1 status. If you had too much unemployment time during your OPT time, or you used one of those day one CPT schools, a change of status is very likely to be denied in that situation. You'd be better off requesting consular processing, knowing that you'll have to exit, get the visa, and come back.
Let's go to questions, Emily. I have questions from YouTube, from Mr. Pratik. He has a question. He has the I-797 approved, which has an I-94 attached, I'm assuming, and he is an advanced parole and EAD. If he goes outside of USA and come back on advanced parole with I-797, can he use the I-797 later on to go for the non-immigrant visa stamping? You can, if the I-797 is still valid and you still have the job offer and all the underlying conditions are met. I'm assuming that on the EAD also you're still working for the same company that filed the 797. You can still use the I-797 for the next time that you go for stamping. It doesn't have to be at the same time. You can use it for the next time also when you go for stamping. I have Shino from Facebook. He has a question. How long it's taking for the GC interview after biometrics in the current situation? We're noticing typically timings of about 12 months to 16 months right now for them to ask you to come for the interview. However, though, the online status of the USCIS tells that it is 36 months though. So if by any chance you don't fall into the category of 12 months to 18 months, if you fall back, there's not much that can be done. If you contact the USCIS, they will show the online chart that's saying that you have to wait for 36 months before you will be called for the interview.
Vishali from YouTube wants to know what the PERM processing time is like because the H-1B max out time is coming up soon. So we started receiving PERM approvals for cases filed in April this week, so it's taking about 4.5 months for the normal processing time for PERM.
Can people on H-1B travel to India, go for H-1B stamping in India? This comes from Rahul Chavla from Facebook. Yes, if they were present here in USA on June 24th, 2020 on a H-1B status, they will not have any problem whatsoever at all in being eligible to get the stamping. Please note that if you're going to India, there are no appointments available until February of 2021. No appointments are available.
Sravani from Facebook is currently on H-1B and wants to apply for an H-4. She wants to know what will be the effective date of the approval. Should I wait for it to be approved or from the date I apply for the H-4 application? So it's actually your choice, and it depends partly on whether you're able to continue maintaining your H-1 status. So assuming that your job is going to be continuing and you want to keep working, you can continue your H-1B status while the H-4 is pending and then to convert to H-4 once it's approved. However, if you don't want to continue working or if you're losing that job, then you can request the start date as of the day you're applying for the H-4 and stop working from that point.
Question from Rahul Chavla. Again, good question. Is there any news on making priority date current for everybody and allowing the people to file the adjustment of status? Rahul, what happened was that about a month ago or 3 weeks ago, Trump tweeted saying that he is going to resolve all the employment-based immigration problems by himself. That's what the statement he made, and that's where we got some clue saying that could he make the priority date current? That's the only solution that we can think about, because there are technical things that where he can tweak a little bit on the regulations and allow people to file the adjustment of status. Now, after that statement has been made, no other further statements have been coming from Trump administration or Trump by himself, though. At the same time, when he made that statement, about a week before or a week afterwards, he also made a statement that he, with the executive order or with the cooperation of the Congress, will be giving citizenship to the DACA kids. These are the DACA kids are the people who are here unlawfully, but who came when they were under 15 years old. Obama administration has given them employment authorization. Trump said he's going to cancel it. He tried to cancel it, but the Supreme Court blocked it. But then he said that he's going to give the citizenship to them. So it threw most of the immigration pundits off the roll. What is he trying to tell? What is he trying to do? So in that confusion, there was some discussion on whether or not there is a chance that he make everybody current and file, allow the people to file in the adjustment of status. That's what happened in 2007, about 13 years ago, but everything was made current and everybody was allowed to file the adjustment of status. However, Rahul Chawla from Facebook, we haven't seen any follow-up things coming from the Trump administration. Trump in general is from a platform of anti-immigration base. That's what his platform is. However, though, these statements, what he made, we don't know if he's trying to attract some of the immigration communities. When he's running low on the numbers, which seems to be the stats say, I'm not taking which side I am at, I'm just telling what the stats are saying right now. There is a chance that the president can make some drastic changes, and we don't know what those things could be to attract the immigrant communities, especially for those people who are U.S. citizens coming from a particular countries. They may try to tend to favor if their fellow countrymen were being favored by the president. So we may expect some drastic things coming from the Trump administration. That's a guess that we had based on the 2 tweets that he did.
Vicky from YouTube has an H-1B that is in process right now and wants to know what happens if the priority date becomes current. Can the green card process continue if the H-1B is still pending? So yes, you can still file the 485 and continue your green card process. However, you do need to get that H-1B extension actually approved. Depending on the timing, if your old I-94 has expired more than 6 months ago and you've been relying on the pending H-1 and then you file the 485 and your pending H-1 gets denied, that could cause a denial of your 485. So as long as the H-1 extension eventually gets approved, it was safe to file the 485 when you're in that situation.
I got 2 questions with regards to the place of working. One from Mr. Bhattacharya. His question is that he is in India right now, stuck without a visa appointment. How long can he work in India? Will it affect the H-1B though? Well, if you are in India, if you are working in India, you are not considered to be an H-1B. You're an Indian, I'm assuming that you are an Indian citizen. So if you're in India, you're working, you don't need any work permit at all. However, though, when you want to return to this country, assuming that if you have the visa stamped already in your passport though, be careful when you are entering into United States. The CBP may ask the questions, hey, you have been out for 8 months, do you still have the job in USA or not? They will be asking those questions. So if you're trying to come back on the visa that you already stamped in the passport, make sure that your HR is aware that you're coming. Make sure you get a fresh dated letter saying that you still have the job with that particular company in that particular position with a salary of what is being prescribed in the H-1B application. Please get that fresh letter and have them available. Now, if your visa is not stamped, when you're going to the consulate though, make sure that that you satisfy the consulate, the consular officer, that you still have a job in USA, and as long as the job exists, you still should be able to get the visa stamping, assuming that you don't, assuming that you're applying in January of 2021. There's a second question. A person asking that the H-4 visa person, he is an H-4 in the country, he doesn't have a work permit. Can he work for an Indian company and that Indian company is serving Indian clients? That means that no US, it is not a US company and all the clients are also in India. But he is here on H-4 without a work. Can he work? The answer to the question is simply no, you cannot. The governments at this point of time only recognize where your butt sits. That's the word that I use, is where your butt sits. They don't recognize cyberspace as a space. Not the US government, not the Indian government, both governments at this point of time do not recognize cyberspace as a space at this point of time. So you are subject to the laws of the country in where your butt is sitting at. Since you don't have a work permit, you cannot work in United States.
Shilu from Facebook has an H-1B that's expiring next year, but due to job loss is currently in the 60-day grace period. At the same time, his wife is outside the U.S. and been trying to get an H-4 visa stamp and wants to know if she can still attend the interview given his current status. I would recommend that you first apply for and receive your H-1B transfer approval, preferably in premium processing, and only then should she apply for the H-4 stamp. I think it's very possible that if she applies in the current situation, that she may put in administrative processing or have the visa denied, particularly if your old employer has withdrawn your approval notice. They won't be able to give her the visa.
Shashank has this question. He's applying for an EB-1 green card through an employer. Tentatively, by what time is he expected to get the green card? Shashank, I'm assuming that you're an Indian national born in India, and if we go normally though, I'm expecting the EB-1 priority date to be current next year, Emily.
I would think so.
EB-1 for Indian nationals should be current next year. So that means somewhere between October and September of 2020, October 1st of 2020 to September 30th of 2021, we're expecting the priority date for you to be current and you can file the adjustment of status. So if everything goes according to the plan, you may get the green card anywhere between 2 to 3 years. That is my expectation, but Shashank, I have been wrong in estimating the priority dates many times, believe me on that. And so I'm expecting things to go through smoothly. If you go through smoothly between 2 to 3 years, that's my expectation, but as I said, I have gone wrong many times before. I have this question from Raju Tapilia from Facebook. Do you think the rest of the world, EB3, will be current in October visa bulletin? Raju, the October visa bulletin is expected to come anywhere between September 10th and about September 20th. That's when they will release October. We are expecting the rest of the world to be current in October. That's our estimate though. Now, there are a lot of confusion. I've had, Emily, a lot of people getting confused, like rest of the world is going to be current. Does it mean that it's going to be current for Indians? That's the confusion a lot of people got.
Right, yeah, unfortunately, no. We still do have the 7% cap. So there is going to be, continue to be that backlog. We don't think there's going to be enough extra green cards available in order for India or China to also be current. It's just all the rest of the world other than those backlogged countries is what they're referring to.
Emily, this question also related to, I may need your assistance in that, is that have you seen any 485 applications getting waived for the interview and directly getting green card?
Yes, it does happen. There doesn't seem to be any kind of rhyme or reason to it. There's no way to request it. But yes, we have had a number of them approved in the recent months without being interviewed.
And these are the applications filed after March of 2017, which requires mandatory adjustment of mandatory interviews. Now, that's good news. We have seen some, but not all. And you are saying there is nothing we can request.
Right.
Okay.
Yep. Amit from YouTube is currently on L1, which is going to be maxing out soon. The H-1B was applied for but not selected in the lottery. And he wants to know if he has another job offer, is there any way he can change the job in the U.S.? Well, unfortunately, we're very limited in the types of visas available that provide work authorization. The L1 is one of the main ones, and the H1 is the other one. And the H1 does have the cap to worry about. So you have to go through the lottery unless the employer is a CAP exempt employer, such as a nonprofit organization, research hospital, things like that. So that would be one thing to look for, is an employer that's not subject to the CAP. Or the other main employment authorized type of visa would potentially be an O1, if that's something that you might qualify for, but it is very limited. That's why so many people have to get the H-1B visa, because there aren't many other options out there.
There are a lot of questions coming on the H-4 EAD. There's been a significant delay on it. A lot of people are asking questions with regards to the litigation. Yes, Reddy Neumann PC is starting the litigation in the 3rd week or 4th week of September. That's a plan that we have. If any of you guys are interested in, you can drop an email at info@rnlawgroup.com. We're going to give the more details on that. We do conduct every day free conference call for you guys to come in. The conference call is at 11 a.m. Central Time. So if you send an email to us, we will request you to come to the conference call so that you can go over the details to see if you fit into it, and if you fit into it, would you like to proceed with that? That will be, you can send it to info@rnlawgroup.com. That's the best thing that you could do. Any other things on?
Not on that. Drew from Facebook recently had his EAD denied. This is the OPT EAD for F1 students, and wants to know how he can reapply for the EAD application, because the university is not going to be able to get him the new OPT recommendation. So I've been seeing a number of these types of situations recently for people that applied for the OPT back in April, around their graduation time. Something or other goes wrong in the application and they're receiving denials right now. The difficulty is, because your 60-day grace period has ended, there really isn't an option to refile the I-765 application, because you're very strict in the deadlines and the dates for filing that. Your only real option is to file a motion to reopen or a motion to reconsider if you think you can overcome the grounds of denial of the original application. Otherwise, you're looking at possibly reinstatement of F1 status that does not provide OPT. Changing status to another status is really not an option, because you're beyond your 60-day grace period. So you'd have to exit the country if you don't do the reinstatement or MTR.
Pranit has this question. I lost my job. It's getting to 60 days. Can I apply for a change of status to F1 and revert back to the H1? One problem, Pranit, you have is that if you're applying for the F1 visa status, you have to maintain your legal status until your F1 is approved. Now, since you are going to maintain only legal status until 60 days after you leave the current job, so you cannot maintain the status until the F1 is approved. So that is not allowing you to keep the status though. If you want to, you may want to consider B1. That's one thing that you can consider. If you're eligible for H4, obviously we will request that you choose the H4 option rather than actually choosing the F1 option. But F1 definitely is not good. B2 is better than F1. H4 is even better than B1. Sunny has this question from Facebook. His SOC code has been changed now, and previously on this I-140 approval, he had a different SOC code. Does he need to file a PERM and I-140 application again? Sunny, the rule says that if it is a natural increment in the position, you don't have to do any amendments for the labor and I-140. But if it's unnatural position changes, then it requires. What do you consider, what do I consider natural changes and what do I consider not natural? For example, if you are going from a system analyst to a senior system analyst, or you're going to a senior software manager, software engineering manager, those kind of things are considered to be natural. But however, let's say you're going from a system analyst, software system analyst, to a mechanical engineer, that doesn't look to be a natural increment in the position though. So if it is within the software field and you have the labor certification and you're just going for a little bit higher position, you don't need to file a labor and I-140 again.
Dinesh from Facebook wants to know his H-1B RFE was responded to 3 months ago, and USCIS is still not processing it. I'm a little unclear. I'm guessing that it's already in premium processing and it's still taking 3 months. We have seen a number of cases in that same situation, and all that can be done is your employer continues to follow up with USCIS and put in a service request for outside normal processing time. But because it's already in premium and they've exceeded the 15-day processing time, they should be issuing a refund of that premium fee, but you just got to keep following up with them to get the actual decision.
A lot of questions are coming. Now the House has passed a bill where they increase the premium processing to $2,500, and the House bill says that you can do premium processing for H-4 and you can do premium processing for EAD also. Does it mean somebody has to file $2,500, $2,500, $2,500 for 3 of them, is the question. How serious do you think about this bill is going to be enacted into law, though?
I mean, yeah, that's basically what they're saying, is if you intend to file an H-1, H-4, and EAD renewal and want a normal type of service, you've got to pay premium on all 3 of those applications, $7,500. And that is exactly why this bill probably is not going to be going anywhere, because it doesn't solve anything. It doesn't actually fix the backlogs. It doesn't require any kind of oversight to cause USCIS to fix their problems. All it does is require U.S. employers and immigrants to subsidize and pay extra money just to get the basic services they were given before without having to pay the extra money. So for that reason, I don't think it's going anywhere. It was a bill that was passed in the House. The Senate is on recess till after Labor Day, so I don't see it being touched anytime before then. And from that point, I don't think the Senate is going to be as happy about this particular bill, because it doesn't actually do anything other than force people to pay more money to get something that they should have already gotten before.
Well, coming to the politics, Emily, what are the chances of this bill getting passed through the Senate and signed by the President?
I mean, I think any bill right now is quite low passing the Senate. If we can't even get a second PPP or CARES Act or any kind of coronavirus relief, we can't get relief for the Postal Service. I don't think that this bill is going anywhere either.
So this stopgap bill that has been passed has less chances of getting through becoming a law. Certain senators have already objected to this bill, that they're going to put a pause on it. So it looks very bleak that this is going to be passing in the Senate. And also, normally though, the tradition for the Congress, which is House of Representatives and Senate in USA, the tradition here is that the immigration bill should actually originate from the Senate. That's the tradition in USA. So this House bill was just passed to satisfy the constituencies of the particular party that is dominating the House of Representatives, not keeping in mind that this bill is going to be passed. So very less chance that this bill will become a law.
Vikas from YouTube wants to know if he has an I-140 approved from employer A and now he's working with employer B, if the priority date becomes current, can he file the adjustment of status with employer A? Generally, no. You need to have a PERM and I-140 approved with the employer that you're working with now in order to file the adjustment of status. Although the PERM process, the I-140 is the future job that you will move into when you get your green card, the old employer and you both had to have the intention all along for you to join that company back. So if that job is no longer available to you with that employer, you're not going to be able to file the 485 because you need them to sign a 485 Supplement J confirming that the job offer is still available, which it sounds like it probably might not be if you're not with that company anymore.
Ayan Khan from Facebook has this question: can I travel to Canada on H-1B visa, and then can I come back to United States? Yes, you can. There is a restriction from the CBP that you cannot come back through the land border. there is no restriction that you cannot come through flight. So as long as you're willing to take the flight from Canada to here, there is no problem for you to coming back into United States. There's another question that comes from Shravani about the same travel. She doesn't have the visa stamping. She has the I-797 with the I-94. Can she go to Mexico and can she come back without getting the stamp on the visa? Shravani, there is an exemption if you're traveling to Canada or Mexico, and if you have a valid I-94, and you are going there for not applying for the visa, but you're coming back within 30 days after you leave the country, you can come back with the existing I-94. That, in technical terms, we call it as automatic revalidation. That's only available for the H-1Bs and H-4s if you're going to Canada or Mexico. For student visas, there are some other adjacent islands. I don't want to name them right now, but Canada and Mexico, they are safe to travel if the valid I-94 is there.
Anurag from Facebook has an approved I-140 from Company A that was there for about a year before he switched to Company B. Employer A has since withdrawn that approved I-140, so now he wants to know how can he extend his H-1B next year. Well, the good news is the regulation that came out in January of 2017 says that even though your old employer's I-140 has been withdrawn, because it took more than 180 days for them to do that withdrawal, the I-140 can still be used for you to get extensions of your H-1B status beyond the 6-year limit. It can be used for your spouse to get H-4 EAD extensions, and it can be used to retain the priority date. You just can't use it to get your green card. And that's because it was approved for more than 180 days before it was withdrawn.
Venkatesh from Facebook has this question. If he converts I-140 into premium processing, will it has any greater chance of getting an audit or RFE? Absolutely not true. Just because you file a premium processing does not mean that you are your chances of getting an RFE are higher.
Prashantha from YouTube wants to know, a friend has an H-1B approved in the 2020 lottery, has not gone for stamping yet, but has a valid H-4. Wants to know if he can come in on H-4 and then look for a new employer and transfer the H-1B. Unfortunately, no, because you don't have the H-1B visa stamped yet, and it's the new H-1B approval for consular processing, you technically have not been counted in the cap yet. So the only way to do that would be to get the H-1B visa stamp, come in, work for the first employer, and then file a transfer. Otherwise, if you come in on the H-4, the only way to get into H-1 status is for the same employer to file a change of status from H-4 to H-1B using the old H-1B approval notice from the CAP.
Bimesh has this question, can we go to Canada and Mexico and apply for the visa stamping? And irrespective of the result, can I come back to USA? No. That is a danger. Here is the issue. If you go for stamping, if you get the stamping, obviously, Bimesh, you know you can come back into the country. But if you don't get the stamping, that automatic revalidation that I spoke before is not applicable and you cannot come into this country.
KKPSMS from YouTube wants to know, is on CapGap, and what happens if the H-1B petition gets denied? Will SEVIS be automatically expired? So assuming that the denial occurs before October 1st, you have the standard 60-day grace period from the date of the denial for your F1 status to continue. So it's not automatically expired in that situation, assuming the H-1B denial does not include a status violation mentioned about your F1 status. However, if the denial comes after October 1st, your cap gap ended on September 30th, and you're already into your 60-day grace period. So you have until November 29th in order to take advantage of your 60-day grace period. If your H-1B is denied after November 29th, it puts you out of status. You are no longer in F1 status at all.
There is some people asking the question here, while I have the H-4 EAD extension pending, can I work after my EAD expires? Since there is a recent notification from the from the Department of Homeland Security saying that you can work based on the I-797, you don't have to get the EAD card in the hand. There has been a complete misinterpretation of what was being stated there and what is actually some people are implementing. What the recent statement said was that if you have received the approval of the EAD extension, and the 797, that is the document that comes from the immigration, says that the EAD has been approved, but you didn't receive the EAD card in the hand with your picture on it, you are eligible to work. This is, I'm speaking about H-4 EAD. But if your H-4 EAD is not approved and your existing EAD is still, existing EAD has expired, you cannot continue working based on the receipt notice that you received from the USCIS.
Alan from YouTube received an EB-1A approval in October of 2019 and wants to know, are there any chances the adjustment of status can be rejected for any reason? And if yes, what are those reasons? Yes, so having the EB-1A I-140 approved does not guarantee that your adjustment of status will be approved. For adjustment of status, you have to prove that you are not inadmissible. Inadmissible means not eligible to receive a green card because of some issue in your past. Most common would be a failure to maintain status in the past. That could cause you to become inadmissible depending on the situation. If you've been unlawfully present for a certain period of time, that can make you inadmissible. If your medical exam shows that you have certain types of medical issues, that can make you inadmissible. Potential criminal issues in your past can make you inadmissible. If you're a terrorist, could make you inadmissible. There's a very long list of things that can make you inadmissible, but generally for your run-of-the-mill type of person, as long as you've maintained your status and been, not been committing crimes and that sort of thing, you should be in good shape for the 485.
Govinda has this question from Facebook. He has on a H-4 EAD, can you own a sales company and can you do sales or warehouse manager for eBay or Amazon? On a H-4 EAD, Govinda, you can do any legal business, any legal work. There is no restriction, none whatsoever at all. However, though, if anybody is thinking of cannabis, that is the marijuana, don't do it. Even though some people say it's legal, according to the federal law, it's not legal, you can't do that. But, honestly speaking about Govinda, if you want to do the eBay thing, Amazon thing, absolutely. I don't see that as a problem at all. You're good, you can do so, make money and pay taxes. That's what we like in this country. Vikas has this question. Can I publish a book and collect royalties while I'm working on H-1Bs? No, because unless it is part of the part of your company deal where you're writing for the company and it's part of the H-1B description, unfortunately, I have to say no, you can't do that. You can't write a book. You can write a book, but you cannot publish it and collect the royalties on it.
Don Ventari from YouTube is currently on H-1 that's valid until 2022 and will be visiting India in November for an upcoming wedding. Congrats. Wants to know if his wife will be able to receive the H-4 at the consulate. So yes, she is eligible. She's not subject to the presidential proclamation because you are maintaining your H-1 and you were in the U.S. on June 24th. However, the consulates need to be open for this to happen, and they're very, very slow in reopening, very difficult to get interview dates. So yes, she's eligible for the H-4, but she may be delayed in getting that H-4.
Question from, do we need to do biometrics when we apply from H-4 to H-1? The answer to the question is no, Poonam. You don't have to do biometrics at all when you're applying for the H-1B. Absolutely not needed at all.
Poonam from YouTube wants to know, once a change of status from H4 to H1B gets approved, do I need the physical approval in hand, or can I use the website showing approved in order to begin working? So although you have notification of the approval, the actual physical original approval notice with new I-94 is required for you to provide to your employer to complete the I-9 process. The I-9 is a form that's filled out by you and the employer on your first day of work, and you have 3 days to provide your approval notice to show that you've got the valid employment authorization. So you are going to need that physical approval notice in order to begin.
Chital Shah from Facebook has this question. These additional family-based green cards that will be given to the employment-based, will they all be given in the first month of the fiscal year 2021? No, that is not the practice, Chital. They won't give all the green cards in 1 month and sit down the rest of the 11 months. That's not the practice. They normally allocate proportionately instead of actually doing everything in 1 month. That has been a practice of the Department of State. That has been a practice of USCIS.
Bindu from Facebook currently has an EB2 priority date of November 2009 and wants to know if it's advisable to downgrade to EB3. So we have a separate video that we talked about the downgrades last week. If you want to look at that.
Last week there was a separate video on downgrading from EB2 to EB3. Under what circumstances it is advantageous for you, and how does the process work. A separate video is there. It was posted last week on Wednesday or Thursday, I remember, and it's posted on Facebook and YouTube. You need to go through that. It's a 10-minute video. It's a very good thing because it goes through all the question and answers. When is a good time for you to do the EB2 to EB3 conversion? We have done in our office, we have done a lot of conversions from EB2 to EB3, especially when the priority date becomes current for the EB3 and not current for EB2, and they have I-140 approval in EB2. You can request your employer can file using the old labor certification and convert EB2 into EB3 and file the adjustment of status at the same time. So let's say, for example, if the priority date becomes current in the month of October, that's in September, you will get to know for EB3 and you are actually in EB2, you can have your employer file an I-140 and you can file an I-140 and adjustment of status at the same time. That means that if the October becomes current for you for EB3, you are in EB2, you can file adjustment of status immediately and you will not have any problem. But here, one catch point every time I'm mentioning, the employer has to file the I-140. The employer must be willing to file an I-140. If the employer is not willing to convert the EB2 into EB3, then technically speaking you will not be eligible to file the adjustment of status. A lot of people ask the question, is it downgrading? Is that going to create any problem? To tell you the truth though, how difficult is it to convert EB2 into EB3 using the same labor certification? It's like this. Every millionaire is not a billionaire. We know that, okay? However, if somebody is already classified as a billionaire, how hard it is to prove that guy is a millionaire? It's so easy. So converting EB2 into EB3 is very easy task, but it must be done by your employer.
Sandeep from YouTube recently had an H-1B transfer denied due to specialty occupation and wants to know what kind of happens next from here. So assuming that you joined this company based on the receipt notice and now have the denial, that denial does put you out of status. That's not the same thing as unlawful presence. Unlawful presence would kick in only if your I-94 has already expired. So if your old company's I-94 has not expired, then the denial of the transfer puts you out of status. You need to possibly look at refiling that H-1B petition or filing with a new employer. It may have to be a consular processing approval where you exit the country and come back to regain your H-1B status. But definitely contact a qualified immigration attorney to go over your options and understand exactly what they are before you make a decision there.
question from Saurabh that his H-1B transfer is pending over 240 days. Can he work? What can he do? Does he have to leave? Right now, it's very hard to leave. If Saurabh, if you applied for a H-1B transfer, the 240-day rule does not exist. You can continue working if your H-1B is still pending. You can continue working. You can continue staying in the country until that H-1B is adjudicated. There is no reason for you to stop working after 240 days. The 240 days is only when you are applying for the H-1B extension without any amendment with the existing company. It's not applicable when you apply for a transfer of application. I get a lot of these questions. People stay idle for a lot of period of time, waiting for the priority date to become current. When the priority date becomes current, boom, they get into action. So a lot of people are a little bit paranoid. When the priority date becomes current, what do you need to do? Well, first thing is that your employer has to be cooperative. That's one thing. Your employer has to sign a document called 485J supplement. That's one thing you need from your employer. If your employer does not sign, you cannot file the adjustment of status. Now, there are 100 other things that your lawyer will ask you to provide, and they are not that difficult for you to provide. You don't have to take a long time, and I and Emily have done cases. We have done like 50 adjustment of statuses in one day, and we have done those things many times. We can do it, and a lot of other lawyers can do it, not that we. So not much, when clients ask me what are the documents to provide, yes, we need I-94 passport, we need passport pictures, and a lot of different documents are required. We need your mother's maiden name, your mother's name, your dad's name. We need to know where your dad is living right now, what is his date of birth. These are all the things that are easy for you to obtain. And particularly the employees will always be very cooperative with their lawyers. I'll be very surprised that if I call somebody at 10 o'clock and ask, buddy, I want to know your mother's maiden name, I need to put in the application. They'll be very happy to give that. And I mean, they won't tell me, lawyer, why did you call me at 10 p.m. in the night? You should have called me at 5. Very rarely I find those people. So coming to the point on what information is required, all the information that is required for 485, mostly you have it. It may take about 1 to 2 days for you to accumulate all those things and provide. The problem we see is the 485J supplement from the point of employer that you need to get. There is one other thing, a lot of people will get confused with regards to the birth certificate, particularly people coming from India. Some of their birth certificates don't have their name on it. Their mother's name is not available sometimes. Their father's full name is not available sometimes. So they are a little bit hurdles, but that won't prevent you in filing the adjustment of status application though. Even if some technical error is there, you can still file it and you can work on correcting that error later on. If certain document is not there, there are some alternative things like affidavits that you can get it from your cousins. And those affidavits drafts are available on our website if somebody wants to go and look into it. You can get all these things immediately. You don't have to, go work on the adjustment of status right now. You just be prepared with your employer, as long as your employer is willing to. You can do the entire application in 3 to 4 days, and then that's the maximum it takes.
Nyan from Facebook, his wife is currently on TN visa because she's a Canadian citizen and wants to know if there's any way her employer can sponsor her for permanent residence. Possibly. So the issue that this raises is the TN is not a dual intent visa. That means that in order to continue to qualify for the TN visa, your wife has to maintain her non-immigrant intent. However, proceeding with the green card process shows that she has immigrant intent. So we have a conflict there. So the first question would be, is she also born in Canada, or is she an Indian-born Canadian citizen? If she's born in India, that may be more difficult because the processing time may be so long, she'll probably have to convert to H-1B at some point throughout the process. If she's a Canadian citizen and born in Canada to where she's in the rest of the world category, if she's got enough time left on her TN visa and doesn't have any travel plans, it may be possible for her to get the PERM, I-140, and adjustment of status all filed before having to renew the TN the next time, and then it can work out.
Ram Reddy Jetty has this question: can H-1B employees participate in the Senate 386 peaceful protest in Florida? The answer is yes, you can. I don't see any problem in it. I think so. You should. I think so. You're not protesting the Senate 386 bill, but I'm assuming that you want to pass the Senate 386 bill. Obviously, yes. The Florida senator has put a hold on it. I strongly urge all the people to contact the Florida senator to take the hold on it so that the Senate 386 will pass. Yes, you can participate in the peaceful protests that are being organized.
Ashok from Facebook wants to know how many H-4s can be in process at the same time. In this situation, there's an H-1B extension that was approved and an H-1 transfer that's approved, and H-4s are pending with both. There's no problem with that. So as long as the H-4 is maintaining status based on your H-1 status, either with the current employer or the transferred employer, either of those applications can be approved. There's no problem with having two pending at the same time because she was eligible to file both at the time of filing.
It's 6 o'clock, Emily. Thank you guys for tuning in, and don't forget that we do have a daily conference call. It is more interactive in there where you can ask the questions. It's free for you to participate. You can check our timings at rnlawgroup.com from 2012 onwards to right now. Every single working day, Reddy and Neumann PC has been conducting free conference call for people to come and asking questions from 2012 to right now. And don't forget to subscribe to the Immigration Girl blog, which Emily operates it. Any immigration news that comes in that you require, particularly the business immigration people that are on H-1s, L-1s, O-1s, P-1s, Q-1s, and the rest of the immigrant visas. She updates it as fast as, I get the news before I read the first sentence. I get an update from the immigration girl. I don't know how she does it, but don't forget to subscribe to the immigrationgirl.com and subscribe to the news section. Anything else, Emily?
Thanks for joining us. We'll see you next week.
Thank you.